All right, thank you everyone for joining today's webinar to discuss the impact and assessment of coronavirus insurance claims. We are going to touch on a few key topics today, including emergency remediation measures and what the industry-wide standard is going to be for cleaning of coronavirus and using disinfectants, as well as additional living expenses and loss of rent and business interruption claims. I think you all know who we are, but I'm Hope Zellinger at Bressler, Amory & Ross, and I'm here with my colleagues, as well as a special guest speaker, Jeremy Beagle from SCII Global, who is a board certified industrial hygienist. In light of the government orders shutting down non-essential businesses, there have already been nearly a dozen lawsuits that have been filed by various businesses against their insurance carriers based on the denial of a coronavirus business interruption claim. We will discuss those lawsuits in more detail today, but the principal argument that these insureds have made is that carriers had the option to exclude viruses as an exclusion within their policy. And in all of the lawsuits that have been filed, they opted to not include that as part of the policy coverages and exclusions. So they have filed these lawsuits based on the lack of containing the virus exclusionary language. Which begs the question, if the insurance policies require that there be a direct physical loss, and if you later take the position that a virus is not a direct physical loss, why would the exclusion be there to begin with? And we'll go through that and the analysis based on the case law that already exists.
And as we go along, if you have any questions, we're going to have a Q&A session at the end. And I think the best way to facilitate this is to use this platform's chat function. And so if you look at the bottom of your screen, there should be a little like chat icon. And if you go into there, you can type in your questions and they will appear, and we'll try to address all of them at the end. But feel free to go ahead and add them as we go so you don't forget your question, and you can just add them to the chat.
We are going to start this webinar with the conversation that began on March 26, 2020. And that was when Broward County issued its emergency order, Order 20-03, that you will see on the PowerPoint up now. And in this order issued by Broward County, they acknowledged the virus, and they specifically stated that the virus is physically causing property damage due to the proclivity to attach to the surfaces. Upon receipt of this order, we immediately reached out to Broward County. We called Bertha Hendry. This was the woman who executed the order, and we asked for additional information about the basis for this statement. They immediately directed us to Ms. Hendry's attorneys, who asked us to send an email inquiring and containing the specific question. We received a response from the attorney, and in response to our inquiry about how they formed the basis of that conclusion that the virus was causing physical property damage, they gave us 5 primary responses. The first was that many attorneys and administrative staff were involved in the drafting of the order. Second, that none of the drafters would claim to be experts in this field. Third, that the scientific community is learning as we go. Fourth, that the order was put together based on the information known at that time and based on a collective understanding. And fifth, that we cannot identify any specific genesis of that recital, and it would take too long to pull the individuals involved. Needless to say, after our inquiries were made, 2 subsequent orders were issued by Broward County. That's 20-06 and 20-07, both of which removed the language stating that the virus causes physical property damage. Samantha, do you want to discuss a little bit about where we went after that?
Yes, thank you. So after we got that response from Broward County, we still did a sunshine records request because we're lucky enough to be in Florida, where the sunshine laws are very broad and allow us access to government documents just by making a request. So we prepared a formal letter citing that statute and asking both the county attorney's office and the county administrator's office to turn over many categories of documents to us, including lists of every person for both agencies who were involved in preparing all of the orders. We wanted lists of all of the records or reports that they had consulted from any agency, whether federal, state, local, or private, that they came up with in putting out Order 20.0-03, and all of the logs for any conversations that took place, notes for all of the conversations that took place inside the agencies and between the agencies and anyone else. In response to that order, I got a phone call from Mark Journey at the Broward County Attorney's Office, and he said, of course, our records request was very broad because there was lots of different sections within the order. So I had a discussion with him specifically that the language of 20-03 that said that the virus was physically causing property damage was of most interest to us. That's when he cited the subsequent orders that removed that language and said that he believed that sort of clarified the county's position, that it was not necessarily causing property damage, or that they were not standing behind the proposition that the virus is physically causing property damage. But of course, we said we're going to need those records anyway, because we definitely need to know why this was ever put out there. What made Broward County, out of all the counties in Florida, claim that the virus is causing property damage just by physically attaching to the surface of different materials for various periods of time? We're still awaiting those records, but we did receive a confirmation from Broward County Attorney's Office that they are working on putting that request together. They'll give us an update, and we'll of course pass along any information that we receive from them. But we do think it's very important that they took out that provision, because as we all know, in any lawsuit regarding an insurance claim, the burden is first on the insured to prove that a physical loss occurred and a direct loss occurred to the property during any particular policy period. So it's going to be very interesting to see what made Broward County put that order out in the first place, because we certainly want to have that ready in our pockets to know if the plaintiff's attorneys are ever going to rely on the same issue. And as Hope mentioned, there are lawyers who are already filing suits and who are blogging about bringing claims under insurance policies, all different types of insurance policies, homeowner policies, commercial policies, business policies, based on coronavirus contamination. And I believe...
Yes, and so, we're worried about that Broward order because, as we discussed, the plaintiffs are going to have the burden of showing that there was this direct physical loss. And as we're going to get into regarding testing and proving that the virus is even present, they're going to need to rely on anything they can and will, I'm sure, rely on orders such as that. So we're going to talk about some lawsuits that have already been brought about the country. And we're going to start off with one just to kind of set the stage of what's been going on. This was a lawsuit brought in Louisiana. It was a declaratory relief action, and it was of a restaurant under a commercial business policy, and claiming that they wanted a business income benefits due to the loss due to coronavirus. And here are some of the allegations, the key allegations in the complaint. And this kind of shows you the roadmap of how they believe they're going to be able to meet their burden of showing that a loss occurred. They established that the business was in a hotspot area affected by the coronavirus. They discussed that there is no specific exclusion under that particular policy for a virus or a global pandemic. In that specific policy, they actually had an exclusion for viruses dispersed for malicious use or terrorism, but did not have a general virus exclusion, and they pointed that out. They acknowledged that the scientific community has noted that that it causes real physical loss and damage. That is not quite clear what they cited to for that proposition, but they did mention that it is impacting public and private spaces and limiting their use, and establishes that the scientific community has acknowledged that they do attach to surfaces for a period, and they quote up to 28 days. And then finally, they refer to a Louisiana case, Witter versus Louisiana Citizens. Property Insurance Corporation. And this was a case in which there was lead dust throughout the home, in fact, that was affecting the property. Now, it was acknowledged in that case that the lead dust was not actually altering or damaging the structure of the building itself, and that it could be remediated. But the court in that case found that it had rendered the home uninhabitable or unusable, and as such, it rose to the level of being a direct physical loss, even though it didn't actually damage the structure itself. And so we can see that this is the argument that is going to be made. There is not a lot of cases just in the state of Florida, but throughout the country, we have searched for them regarding what constitutes a direct physical loss. There are cases that say it does need to be more physical that we are accustomed to, but we're going to explore the cases that are on this other train of thinking regarding, is a direct physical loss something that can be more intangible if it renders the property unusable? And Krista is going to go ahead and take us through those cases now.
Yeah, so, before we get to the idea of whether or not, we're dealing with a contaminant or whether or not it falls into the pollution exclusion, we do have this initial burden that's going to be on the insured to prove that there actually is a physical loss. And Austin's gone over what, we found here more locally in our home state, but looking across the country, there actually is some very interesting case law on what constitutes and what does not constitute a direct physical loss, especially in the property context where we're used to being able to measure that by structural damage to the risk. But what about the intangible? So some notable cases, and you'll see we've given you all of the citations here for anybody who's interested in looking this up after the fact. But a particular case I want to talk about is the Mellon case, which was actually on the last slide, but it's involving cat odor. So you had a situation where there was an insured property that was being rented out, and there was a cat urine that was producing a very foul odor, and it was preventing the owner from being able to rent out the property. So the question became whether or not this intangible odor constituted direct physical loss. And in that situation, it was remanded back for the court to consider that, saying that yes, an intangible can in fact be a direct physical loss. Some other notable things, or excuse me, notable cases that we want to talk about would be, one is the release of ammonia. There was an instance where there was a release of ammonia in a Georgia packaging facility where it rendered the facility temporarily incapacitated. And in that instance, the court said, yes, that release of ammonia, because it rendered the facility temporarily incapacitated, it did constitute a direct physical loss. There's also case law out there with respect to the issue of asbestos, where the insured has been able to prove that there was asbestos fibers that were released into the risk, and that presented a health hazard, and that in and of itself rendered it uninhabitable and therefore a direct physical loss. So I think that, we have the cat odor, we have ammonia. We also have a situation where there was the disbursement of, there was a methamphetamine lab that was out of a rental property. And the insured was able to prove that those odors from the methamphetamine lab had been released into the property. And obviously when the tenant vacated, that rendered it uninhabitable. That was the argument. And the court bought that argument, said, yes, it's intangible, but it is directly implicates the health and safety of anybody who would be residing at that property.
And I just want to also mention one other case that is kind of on the flip side, and that is Mama Joe's Inc. versus Sparta. That's the citation at the bottom there. And that case is actually an opinion from the Southern District of Florida. And in that case, they found that dust debris from construction that was entering a business that they were having to clean every night did not constitute a direct physical loss. And that case stated that a direct physical loss traditionally is more of an actual alteration of the physicality of the property. However, that case also acknowledged, though, that there is this string of cases where if it is rendered uninhabitable or unusable, it can be a direct physical loss, but found based on these facts in which they were able to stay open and just clean it regularly, that did not rise to the level of a direct physical loss.
Okay, so, thinking about all of this and synthesizing, what does this mean for us in the insurance industry and property insurance in particular. What does it mean for us, and how are we going to move going forward? What are our arguments going to be? And I think that the threshold argument or position that needs to be considered is whether or not the property has been rendered uninhabitable. Because in those cases that we've discussed, whether it be a business property or whether it be a rental property, the argument where the insured has been able to prove that an intangible did constitute a direct physical loss was a situation where it was rendered uninhabitable. So if you take that to the COVID context, we feel that there's a very good argument that there's this extremely narrow window where, or facts and circumstances that an insured is going to be able to prove that there is a direct physical loss, meaning you have to have a situation where there is COVID found in a particular risk. But that being said, it has to render it uninhabitable. And we think that is going to be a big hurdle because of the CDC guidelines. And Linda's going to talk about that. But the idea that, people are supposed to be self-quarantining in their home, and they're supposed to be cleaning. So, assuming that they're complying with the CDC guidelines, we feel it's going to be very difficult, even where a person in a home has found the live virus, to be able to prove that there has been a direct physical loss.
So to piggyback of what Krista's saying, what we need to do in order to be able to synthesize and to analyze whether there is a direct physical loss, we were thinking that we need to go straight to the science, as Dr. Fauci has said, and I'm sure we've all heard over and over again many times on articles and news media sources. So we went straight to the science for what the Center of Disease Control actually outlines and talks about with respect to the coronavirus. As we know, the coronavirus is a disease a virus that causes COVID-19, and there's 6 other coronaviruses that have caused diseases in humans. Coronavirus, and it's a term that's used for the SARS-CoV-2 virus, which the acronym that we have is the SARS, S-A-R-S. So as we've heard time and time again, we've all read articles, we've been inundated with news, people who are suspected to have been tested positive for coronavirus have symptoms of the coughing, the headaches, the fever, and obviously what we've heard, unfortunately, is that the symptoms vary in degree and severity from person to person. And I'm sure at this point in time, we all know someone or have heard someone that has the coronavirus, unfortunately. So when we were looking at the CDC, we wanted to kind of understand what it was that they were saying with respect to, one, what happens if someone is tested positive and has coronavirus and it's confirmed that they have it, and then how does it affect property? And as we've talked about, we make the argument that there's no structural damage to the property, but that it may attach to surfaces. So the CDC does talk about that someone with coronavirus can actually transmit the coronavirus from air droplets or touching different surfaces, and then it will stay on the surface for hours or days. And we're obviously going to have Jeremy Beagle speak to the ability or what it could be take to actually clean these surfaces. But I think it's also important to note that if we look at the CDC website, they actually give different techniques and tips for the possibility to clean and eliminate the coronavirus from a surface. And nowhere in the CDC, and Austin's going to get into this, nowhere on the website does it say that there has to be professional cleaning that is rendered to eviscerate the coronavirus from any surfaces. So something I've also seen that I think also couples with our wanting to go to science and look at the website, I've seen other insurance companies on their LinkedIn pages, on their websites, actually highlight the CDC website and all the different guidelines, which Austin will speak to. And I think that's a very powerful tool that we can disseminate to our insurers and, just have to give them the information, because obviously knowledge is power. So Austin, if you want to speak to exactly the guidelines of how to clean the virus per the CDC.
Yeah, so the question leading to whether there was a direct physical loss, is the home uninhabitable? And the CDC guidelines as of now is to shelter in place, stay at home. And they have actually issued specific guidance papers talking about how to care for yourself at home if you have the coronavirus, how to care for a family member in the home if they have the coronavirus, and specifically how to clean and sanitize your home if someone inside of it is affected with the coronavirus. So to piggyback on what Linda said, nowhere is there a guidance of that it requires any professional cleaning. In fact, what they recommend in these guidelines is to use EPA-approved cleaners that are common household cleaners such as Lysol, Clorox, things that you could receive at the grocery store or at Walmart, and that these can effectively deactivate the virus or kill the virus, however you want to describe it. Jeremy will be able to tell you more about that, whether it's even alive and you can kill it. But the fact is that these guidelines indicate that you yourself at home can effectively sanitize the air with household products. And so I think that would be the argument, is that it does not render the home uninhabitable if you can simply clean it yourself. Piggybacking on the Witter case, where they found that the dust just required cleaning, it did not require it to be uninhabitable. Obviously, this is way more serious than dust, but just because it is very, very serious does not mean that you need to evacuate necessarily to properly take care of it. So once again, these are products that the CDC has them listed on their website, everything that is EPA approved, and Jeremy Beagle will get more into what types of products those are. And we have another presenter, Greg, whose video is not working, but I believe he's appearing by phone. Greg, can you hear us?
I can, and I'm here. Thank you, Austin. Thanks everyone for being here. We're excited also to add Jeremy Beagle, who's a board certified industrial hygienist. And the reason we're so excited for that is that Jeremy can give us kind of a real world experience and some examples in terms of what we're going to expect here and what we can reasonably foresee. And I think, everybody, as we talk about this, obviously our expectations change, but, for the time being, it's foreseeable that, aside from insureds making their own claims, that we'll see some assignment of benefits, coming around and making not only unnecessary but ineffective treatments to purportedly alleviate these issues. Jeremy, thanks again for being here. I think we've discussed this previously, but I think initially we need to start with a positive test on an individual, let alone a piece of property. Is that what you would glean this so far?
Yeah, Greg. So I think when looking at this and looking from an assessment, cleaning, testing, can we first prove that the virus is there on a surface is going to require cleaning? And as of today, there is no commercially available testing that we as a indoor environmental professional can go in and test a surface, send it to the lab and say, yes, we have a contaminated surface here. It's going to require cleaning. So in lieu of this test, what we really need to then focus on, just to start to look at the whole cleaning process, is do we have a confirmed case or do we not have a confirmed case? And from that, the CDC gives us guidance for both. So our next step is going to be, okay, so we have a confirmed case, and we're going to go for cleaning. Is it going to require a wholesale cleaning of the property, or do we need to clean every square inch? Does it need to be professionally done? And I think, this is ever evolving every day, but at this point, not really. It's going to depend on each case. So when we're thinking about remediation and we look at the CDC guidelines, what are they telling us to do? They're telling us to clean and disinfect. Those are actually two different things. So when we clean, we're actually removing grime and other types of materials from the surface. So we clean with soap and water, a detergent. That allows us then to apply disinfectant to that surface. So this also takes us into the fact of, are we killing the virus? Are we deactivating it? And then what are these disinfectants that we're going to use? So a virus technically isn't really alive, and it's technically not really dead. It's floating in between. It requires a host. And we are that host with the mucosal and upper respiratory secretions. That's where it's living. So when we cough or sneeze, when that comes out of our body, that can deposit on the surface, and that's where that's going to live. So disinfectant to work, we need to clean the surface to get down to it. So with the virus, the disinfectant is, with coronavirus, it actually has what they call an envelope. And the disinfectant will be able to get in there and get through the envelope and either kill it or deactivate it. The EPA has, I think Linda and Austin already had indicated, has a list of EPA registered disinfectants that can treat the coronavirus. So what that means is they've actually been, the EPA I think has a two-step process with registering the disinfectant and then showing that it actually can kill. There are many household type of products on there. For if you want to look at, you can just Google EPA N list, the letter N list, and that changes every day. So we can use standard Lysol, various cleaning products that we have underneath our sink, but you can also, there will be more industrial grade type of products. Is that necessary or isn't it? The conditions and the situation are going to dictate that. However, you want to use that because I can have a remediator come in with a, his brand new antimicrobial that he's trying to push off. It's very expensive and it actually doesn't kill the virus. It doesn't deactivate it. So now they're applying something that isn't really going to do anything. So we want to understand disinfecting and we want to understand what we're doing with that disinfectant.
Yeah, and that's understood. Thank you, Jeremy. And I think, this slide in particular dealing with the HEPA filter and the foreseeable use of foggers and other equipment that will probably arise out of this, out of the COVID situation, we're wondering, like you said, it really is going to be a case-by-case basis. I mean, if an affected individual enters a property, the top-down cleaning from, the first floor, the second floor, the garage, everything isn't necessarily required. It depends on where that individual was or where the particular germs are or where the virus is present. Is that basically my understanding of your recommendations?
Yeah, we're going to look at the situation. So you mentioned fogging, you mentioned use of HEPA filtration. If we do a parallel with, say, like mold abatement, a lot of times there becomes question into invoicing and the extent was it necessary when we were reviewing mold remediation or even emergency service invoices. So say we have a low volume refrigerator leak and we got maybe a square foot of mold growth. All of a sudden you get an invoice for where there is fogging completely throughout the house. They're going to base that upon whatever testing maybe they had a mold assessor come in and do. And in most cases, that testing is extremely limited and doesn't provide anything to substantiate. They will use HEPA filtration. And again, there's a use for it because especially within mold remediation, things like that, we're kicking up dust. We're trying to keep the environment clean. With what we already know and what the guidance is providing here, we're cleaning surfaces. So is HEPA filtration useful by itself? No. The latest research, I think from the New England Medical Journal, indicated that they believe that the virus can stay airborne for about 3 hours. So when you're cleaning or when you're going in and out of your house, having the air filtration running, it can be useful, but you can't really use it by itself, and it doesn't really do what the cleaning disinfection, because we're trying to clean the surfaces. That's our concern here. Our primary route of exposure is from the mouth and from our nose. So we always be required to wear face masks. What's secondary is the surfaces. There's a belief that we can contract the virus if there's enough of a viral load on that surface. So from a cleaning standpoint, that's where we want to focus. Now, are foggers useful? Sure, it depends on the extent. But what I think what we have the gist of here is if we have a residential property and we have nobody confirmed, you're doing general hygiene. If you do have somebody confirmed, and then they can shed the disease, we can go in and clean the touch points, we can clean the rooms that they're in. If I have a large home, 3,000 or 4,000 square foot home, and I'm positive, so I come and I quarantine and go into one part of the house, and I'm not interacting with the rest, that doesn't specifically require us to have to clean the whole entire house. Professionally, we really need to focus on the room that I was in, really any contact, and then high touch point areas and things like that. So, you know, there's a lot that's going to be evolving. Even from the testing perspective, like we talked about before, there is no test for the issue. There may become one, and then it'll be useful and help us solve a lot of these questions. But right now, we need some guidance, and we're using common sense. And, you know, a lot of this equipment may not be necessary for some applications, and it could be necessary for others. It'll take us to look at each one separately.
Understood.
And Jeremy, I just wanted to ask, with the lack of testing, and you've described that the only test to really test is to see whether you've likely deactivated it by the fact that you can tell that there is nothing living like a bacteria on the surface. So with that lack of testing, what would be the appropriate investigation for an insurer to conduct? I mean, does it even make sense to inspect the property if there is no surface testing that can be rendered?
No, that's a good question, and I don't think so. If we don't have let's put it back to if we don't have a confirmed case. If we don't have a confirmed case, I don't think there's really a whole lot that needs to be done. What we need to be, although there could be the argument of, you know, asymptomatic and we don't know if we're bringing it in or not, but we still move forward with our general hygiene of cleaning surfaces, washing your hands, social distancing, things like that. But you brought up a good point with the testing. So while there is no testing to confirm what's on the surface, we can confirm, really the only testing can be done is to actually confirm whether cleaning's been done. We cannot, even after cleaning is done, whether it's professionally or not, we cannot confirm that the virus has been killed because we can't test for that. So we use bacteria and fungal spores as a surrogate. They are more resilient to disinfectants and cleaning. So if we can show that we've cleaned a surface, whether culturing or using ATP methods to show that the bacteria is gone, that can show we cleaned. That's all we can do. If we come from with an actual case where we have a confirmed case, I think from an assessment standpoint, if we're going to go in there and assess, we want to look at, has it been cleaned? White glove test, we can use the testing that we already talked about just to show cleaning. What are the conditions? Have the property owners cleaned the space, or if there's been professional mitigation done, have they cleaned their space properly?
Right. And then moving on to slide 26, I mean, you touched on this as well, Jeremy, the efficacy and necessity of the remediation. Sorry, it's a tongue twister. Ultimately, one of our questions that we've received is that, you know, if the cleaning is done and an individual is to leave the property, to say go outside and pick up an Amazon package, or to go to Publix, or to you know, receive the mail. I mean, we've already established that there's no way of testing for the virus on surfaces. Is the cleaning that could have been done all done by the person leaving the property?
And if I could just add to that, if you could also just speak to, because this slide talks about the time, you know, that the virus stays alive, if we could also address, you know, what is appropriate amount of cleaning for, let's say, a landlord in between tenants to avoid some sort of liability.
Okay, so we'll go back to the first one from Greg. If we've cleaned and then you go out and about on your day, you no longer have the virus, you need to be doing the recommended hygiene, the physical distancing, you know, wearing gloves. When you come into your house, you're washing your hands. There's nothing yet, you know, you've cleaned. Now it's on you as the occupant of that space to do what you need to do to keep your area clean and reduce your risk of recontaminating that space. So if I clean and then I go out and I come back, there's no reason that it needs to be cleaned again. I need to be cleaning my space and cleaning myself to reduce my risk. So from the time perspective and with your landlord scenario, it does desiccate over time. It does deactivate. I don't think it was Chris, I forget who had a slide prior with 28 days. That's actually the longest I've seen Right now, they're talking around 9 to 10 days, maybe on stainless steel. They're still finding it or through viral. So if we're at a period to where we have a landlord, the tenant moves out, it's been unoccupied for 10 days to 2 weeks, really that should be deactivated. I think it's beneficial for the landlord to document the space, probably just clean the touch points like we talked about, just generally, to show that, because then it just lessen anybody's concern. But yeah, this will deactivate over time. So that's definitely going to be a really important part. And when we're looking at the various cases on what needed to be done and what didn't need to be done.
Well, thank you, Jeremy. Appreciate that. And we'll come back if we have any other questions on this. So another area we want to talk about is business interruption. Business interruption, there's been lots of claims for this, and this seems to be making seems to be leading the way as far as the COVID-19 claims go. In order to recover business interruption, obviously, there's going to still need to be that direct physical loss. Now, some policies do have the specific virus and bacteria exclusion. If your policy has this, you're good. This language is very clear that is excluded. As Hope mentioned at the beginning, the fear is that plaintiffs are going to use the fact that an exclusion exists to show that under an all-risk policy, if you do not specifically have the virus exclusion, then that means it is a direct physical loss that would be covered under the policy. Now, we still believe that there's going to be huge evidentiary hurdles for them to prove that, even if they can prove that that it could potentially, in theory, be a direct physical loss. As Jeremy said, there is no testing to show that it is present. And so to show whether or not your specific business was affected by this as a direct physical loss and has led to a loss of income is going to be very difficult for them to prove. While some policies have this virus exclusion, others have a more limited exclusion as to just terrorism or malicious use, and other policies are going to be completely silent as to it at all. Here's some language of an example from a business interruption policy. It says the suspension must be caused by direct physical loss of or damage to property at the described premises. So again, has the virus itself rendered it uninhabitable, and can you even prove that the virus is there? That is going to be difficult for them to go ahead and prove, we believe. Some policies have a definition for property damage. That anything in any policy language that we have that we can utilize is going to be helpful. Here, this was an example that described it as physical injury to tangible property. And that might be something we could hang our hats on and say, it's not actually doing anything to the property itself. The property is not a host to a virus. It does not actually make the property sick, and so that we can use that. But a lot of policies are silent as to what constitutes property damage, and that goes back to the case law we had discussed before. Now, other businesses are claiming business interruption due to the act of the government, of the civil authority. And this could on the surface seem very much to apply, because it is obvious that businesses such as restaurants are shut down all across the country because of the act of the government. But the policy, even in this section, here's an example of language, says that the action of civil authority that prohibits access to the described premises due to direct physical loss of or damage to property other than at the described premises. So once again, the trigger here is going to have to still be a direct physical loss that would otherwise be covered under the policy. And that is what is triggering the civil authority to block access. So there's 2 points I'd like to make based on this language. One is the language relating to access. It's talking about it must prohibit access. So we got to think, I think it serves to first just paint the picture of what this would typically be. A fire to a building across the street. Your building is not affected at all. You could be operational, but the police and the fire department have shut down the roads for an extended period of time. And so that is now literally restricting access to your business. Here, there's virus somewhere, we don't exactly know where, and access to the business is not so much restricted as that you are not allowed to be open. So argument could be made that it's not an access issue. There's no problem getting to the restaurant, for instance. In fact, you may still be open for business for takeout, carryout, or some other limited availability because there is not an access issue. The other issue is, again, back to whether it's a direct physical loss. Before we were talking about the burden of proving direct physical loss at your own premises and how difficult that would be. Here, there needs to be a direct physical loss covered on the property somewhere else. Now, this is this can kind of go both ways because it is almost very difficult to prove, but at the same time, the plaintiffs are going to be able to argue that, well, quite clearly, there is, coronavirus affects surfaces. There is somewhere where the surfaces are contaminated and that area is uninhabitable. And because it is generally unsafe to be in places where the virus is, these orders have been issued, and as such, we are forced to be shut down. And that is going to be the argument they make. Now, as far as going back to access, for businesses such as condominiums or apartment buildings, again, arguments regarding loss of rent or inability to pay their rent, etc. Again, that is not directly related to a lack of access because of the government. I think that is too many degrees of separation away, and the lost rental value requires a direct physical loss. And again, this civil authority requires a restriction of access, which if your home is still open, that would not qualify.
We want to delve briefly into some of the lawsuits that have already been filed and the allegations that have been made against the insurance carriers for denying the coronavirus business interruption claims. We don't have slides on this. I'm happy to provide the actual case citations to everyone after this webinar. But the first case I want to discuss is Mitchell Brothers versus Cincinnati Insurance. And this was a lawsuit filed on April 3rd in Ohio. In that case, the government issued a shutdown and ordered all non-essential businesses to close. Mitchell's is an ice cream store, so they closed down and they submitted a business interruption claim to their insurance carrier, citing to that civil authority language. The insurance company issued a reservation of rights letter and ultimately denied the claim, saying there was no direct physical damage. In Mitchell Brothers, they filed a lawsuit seeking a determination from the court that the virus did cause a direct physical loss to the property. In Big Onion versus Society Insurance, that's a lawsuit that was filed on March 27th, 2020 in Illinois. It's a three-part complaint because unlike Florida and other states, as we know, you can file not only your breach of contract action, but also your bad faith claim at the same time. And in the Big Onion case, they filed for breach of contract, declaratory judgment, as well as bad faith. Several owners and operators of various businesses band together and sued their insurance carrier after a denial of a claim for business interruption. They allege in this lawsuit that the carrier denied their claim with a blanket denial within hours of submission of the claim. And they also said that the insurance carriers denied the claim without conducting any meaningful investigation. And they ultimately asked the court in the Big Onion case to determine if this all-risk policy, under this all-risk policy, if this is considered a direct physical loss. And finally, in the French Laundry case versus Hartford Fire Insurance, this is March 25th, 2020 out of Napa County. In that case, there was a denied business interruption claim for the restaurant. And the lawsuit alleges that not only does the policy in which they sued not exclude viruses, the policy actually grants coverage for loss or damage caused by a virus. And every policy is different. There's actually policies out there that contain a specific pandemic event endorsement. And that's an endorsement that was created to extend coverage for specifically citing to SARS and other viruses. And in the French Laundry lawsuit, they cite to the March 18th, 2020 order that had been issued by the government. And within that order, they stated that there was evidence of physical damage to property and that the deadly virus physically infects and stays on surfaces for up to 28 days. And so this all brings us back to the Broward County order that was issued, 20-03, that we are still investigating, and that obviously there have been other issues, orders that have been issued since. But in that French Laundry case, they used the entire governmental order that stated that it could cause physical damage as the basis of their lawsuit against their insurance carrier.
And we just want to remind you, if you have any questions, please add it to the chat. I just wanted to kind of synthesize what we've all heard here today. And that's one, if there isn't a virus exclusion in the policy, the first step is going to be whether or not there was a direct physical loss. There is case law out there that it does need to be more of a tangible destruction of property, and that can be argued. But there is this other chain of case law that something intangible or visceral that renders a property uninhabitable can be a direct physical loss. So in that question leads to whether or not the coronavirus renders property uninhabitable. The CDC guidelines as of today says there's no reason to vacate your home. You should in fact do the opposite, and you can clean it yourself. So to combat whether that this is a direct physical loss, under the more lenient description of it, you would say that it does not render the home uninhabitable. Then also the plaintiffs are going to have that heightened burden of proving that a direct physical loss occurred at the property. And without an actual person testing positive at the property, there's likely no evidence at all that the virus is even at the property, because there is a lack and inability of testing. Hope mentioned some carriers that were sued denied it just based on reviewing the papers. And there's going to be questions about what is an appropriate investigation into whether or not there is a loss to the property, if there is not a direct exclusion. Being that there is no test to conduct and an inspection in these times are likely also not necessarily safe, I think we're probably going to rely on recovering as much information from the insured as possible, whether there's any tests and things of that nature.
And with the issue with the blanket denial, that was in the Big Onion case where there were several restaurants that had banned together. I think what happened was they immediately said we had to shut down because of coronavirus, and they got the denial within an hour. So I don't think a meaningful investigation can mean different things, but I think when you get a blanket denial, as they've described it in the complaint, that was the cause for concern leading to their bad faith allegations. And of course, as we've all seen litigating throughout this country, these are just allegations that have been lodged. They were just filed within the last month. There has been no discovery or court determinations, but we will be sure to track all of the results from that.
So we're going to open up the chat now and take a look at some of the questions that we've received here.
And because we have a lot of people involved, what we're going to do is go through some of the questions. We'll answer a few over the next 10 or 15 minutes, and we know where to find everyone. We'll reach out to you guys as individuals to address anything we can't get through today. And of course, you guys know how to find us as well.
So Jeremy, maybe you can answer this first question, is that we've been seeing online these remediation companies claiming to be certified in viral remediation. Is there such a certification? And if so, what does that entail? And what can we do about any sort of falsified credentials?
Yeah, I believe through the IICRC, there is certification for biohazard and infectious disease. So these, if you have this certification, you have knowledge base in how to assess and then clean and apply disinfectant and take care of that area. So this kind of goes back to, we really need to go with this. It's going to be case by case basis. So if you have a large scale cleaning, you actually should have a professional company come out to do it. They know how to utilize chemicals that are being sprayed or being applied. They have the training for that. They wear the PPE. One thing we don't want is homeowners, back in the day, mold started to become big, and everybody got their spray can of bleach and just started spraying it everywhere. And that's not good. That can cause a problem. So there are certifications for that. We just have to look at each company and see what they're claiming, either what their certification is or their training and who their affiliation was with where they received that. But yes, there are companies that specialize in trauma, biohazard, and infectious disease cleaning.
Another question we have is whether or not it's a fair comparison as to an evacuation before a hurricane and these COVID closures. And I think that is a really good comparison, because the evacuation phase before a hurricane is to prevent damage, to prevent loss of life, and is not exact, and it's before there is the direct physical loss. Whereas, and similarly here, a lot of these closures are not because there's necessarily COVID-19 at the premises, but is there to prevent the spread. And so I'm not sure, I hope you've come across yet any cases that are analogous to claims during the evacuation before the strike of the hurricane. But that is definitely something to look into, because we have considered the fact that one of the reasons that some of these business interruption language would not apply is because it is not being done because of the direct physical loss, but instead to prevent the direct physical loss. And I think that is a very valuable distinction. And Hope, I don't know if you had a chance to look to see if there's anything about this Panama City order. We had several questions about that.
I'll pull that and then get back to people who need the answer.
Yeah, we had not seen the Panama order yet, but we know that they are around, not just not just in Florida too.
But yes, and Panama City itself has also been issuing warnings to its citizens to be on alerts from scammers who are trying to take advantage of this COVID situation. So that would be people who are trying to say that they can come in with cures or with some sort of remediation that people might need. So Panama City might be sending out kind of mixed signals, and we'll look into that, and we'll do a public records request for them as well.
Another question we've received is whether or not there's any research that COVID-19 at the microscopic level can actually does do some sort of damage to a property underneath the microscope. From our research and our discussions with doctors, and as Jeremy maybe can even talk about some more, is being that the virus is so small and not alive and cannot, does not actually interact with the property itself, and that it will naturally deactivate over a period of time. We do not believe that it causes any physical damage more than any other microscopic particle that will just float down and land on the property. Jeremy, do you have something to add to that?
Yeah, I think actually you're spot on. We're going to clean. We're going to clean and disinfect. So if we have hard surfaces, we can apply the cleaner and disinfect. If we have porous surfaces, the other thing too, which I don't think we really talked about, was heat. Heat deactivates it. I think it's above, if I recall, 133 degrees, 140 degrees. So there's a lot of commercial type equipment that we can clean porous materials with to get it to that temperature and above. So yeah, I'm in agreement. It's not really, I'm not an attorney, and the property damage, that definition's for them. But from just what's on there, we have a substance on the surface that contains the virus, and then we can clean that, and we can bring that virus back to as close as what we can consider to a pre-loss condition. This isn't we always have the argument with Category 3 releases where we have water that's being absorbed by porous materials, drywall, things of that nature that have pathogens, that have bacteria that are considered hazardous. A lot of times we want to remove that if it can't be cleaned, if we can't get disinfectant in there. I mean, here we're just on these surfaces. So I think we can get these surfaces clean. There's been no guidance that's even discussing removal of building materials. So, I think that line of thinking is it's common sense. That's what a lot of what we need to be thinking about right now is use what information is available and then make common sense judgment calls with it.
And then also, just one thing I want to touch on is really the difference between bacteria and virus, because I know a lot of policies do exclude bacteria, maybe in conjunction with fungi. And I just want to make sure there's no confusion regarding the two. And if you can talk about that, they're actually quite distinct, and maybe that would lend to wanting to stray away from any reference to that sort of policy language.
Are you asking me from the difference?
Yeah, that bacteria is quite distinct from virus. They're not
exactly. So I think we can move on a brief
try to interchange them either.
Right. So we touched on it briefly. Viruses, they require a host. If it does not have a host, it will deactivate or die off. Bacteria, lives on its own. It's its own organism. Same thing with fungal spores. So they use the environment around them to gather whatever, whether get their food basically to get their energy to survive. So with viruses, it's even when we think about creating a vaccine for a virus, vaccines don't really kill the virus. We control it, and the researchers try to find a certain part of that virus that they can deactivate, which then will actually stop. You can still have the virus, it just won't do anything. So they are two different types of organisms. And really the genesis comes down to one is living and one is floating in between, and you can either say it's not living or it's in its own little world. It does require a host. It cannot survive without cells that can feed people. Is that get you there?
No, that's great, Jeremy. And these are the questions we need to be asking. What we want to avoid are all the leaps that we anticipate will be made. Oh, there's coronavirus. We need to spend $10,000 cleaning homes, every home in Florida. We need to ask these questions, follow the CDC. We will be here to help you guys, and we will continue to go through all of the research and the case law that exists throughout the country about what constitutes a direct physical loss. And we definitely want to encourage having breakout sessions with everyone on this webinar here today. I had one more question about the last lawsuit that I had gone through that's already been filed. The case name was French Laundry. It's Thomas Keller's famous restaurant in Yountville in Napa Valley.
Oh, wow.
Did you do that?
I didn't know it was the same French Laundry. Yeah.
Napa County. So French Laundry versus Hartford Fire Insurance Company, March 25th, 2020. And that was the last lawsuit that I went through where they had that similar order from Panama City, Broward County, that says it's causing physical property damage. And that's the question for us all to figure out. In our investigation so far, we have not found a doctor, an industrial hygienist, the government, or anyone who can give us a scintilla of research saying that it does cause physical property damage. So thank you guys so much for listening today. We look forward to talking to all of you after the webinar.
Bye-bye.